Good day, everyone! We are the Group 9 and we are tasked to discuss the Katarungang Pambarangay. So what is a Katarungang Pambarangay? A Katarungang Pambarangay is a system of dispute resolution instituted in all the barangays in the Philippines that seeks to promote the speedy administration of justice. From the name itself, it is a justice system that is administered by the basic political unit of the country, which is the barangay. In some areas where courts are inaccessible because of its location and because of its prohibited cause of litigation, the barangay justice system, with all its limitations, can be the only venue that the poor can avail of in the resolution of their disputes. Moreover, as stated here, the primordial purpose of Katarungang Pambarangay is to promote the speedy disposition of justice by minimizing the indiscriminate filing of cases in courts and thereby enhance the quality of justice dispensed by the court. So, to reiterate, it provides a settlement for disputes between individual residents for the same city or municipality through the process of mediation, arbitration, and conciliation. As mentioned, to simply put it, the barangay justice system provides a friendly, inexpensive, and speedy forum for the settlement of disputes where the parties can freely explore options for amicably resolving their disputes without resorting to the courts. It perpetuates and recognizes the time-honored tradition of amicably settling disputes at the community level. Here, amicable settlement is reached through mediation, which means a process wherein the lupon chairperson or barangay chairperson assists the disputing parties to reach a settlement by consensus that jointly satisfy their needs. Arbitration is also a process wherein the third party from outside the judicial system is chosen by the parties to hear and decide for their dispute. And lastly, conciliation is a process wherein the pangkat forgoes the power to decide or recommend but assists the parties to isolate issues and options to reach a settlement by a consensus that jointly satisfy their needs. So, what is the significance of Katarungang Pambarangay on cases filed in regular courts? According to Section 42, Paragraph A of Republic Act 7160, it requires the parties to undergo a conciliation process before the lupon chairman or pangkat as a precondition to filing a complaint in court. This rule is also enunciated in the case of Lambuan versus Ronquillo with the SCRA number 489-650. Since the barangay justice system is envisioned to complement the courts in administering justice, the cases covered by barangay justice system it is a compulsory for them to have the barangay justice system proceeding first before going to court. Failure to do so would mean the dismissal of parties' claim or counterclaim. It is only when the barangay justice system has failed to resolve the dispute that the parties will be allowed to bring their case to the court.
Now, let us discuss the legislative mandate and the legal basis of the Katarungang Pambarangay Law. So, initially, Katarungang Pambarangay Law was embodied under Presidential Decree number 1508, which was promulgated in 1978. However, eventually, when laws and statutes relative to local government were codified or merged into one code, the Katarungang Pambarangay Law was then embodied under the Local Government Code, specifically under Section 399 up to Section 422. So afterwards, the Supreme Court issued Administrative Circular number 14-93, which was issued on July of 1993. So the circular issued by the Supreme Court provides for the guidelines on the Katarungang Pambarangay conciliation procedure, which was issued to prevent circumvention of the revised Katarungang Pambarangay law. Now, where can we find the legislative mandate which requires for certain cases to be subjected first to barangay conciliation before filing of a complaint in court? So that mandate is provided under Section 412, Paragraph A of the Local Government Code, which states that no complaint, petition, action, or proceeding involving any matter within the authority of the Lupon shall be filed or instituted directly in court or any other government office for adjudication, unless there has been a confrontation between the parties before the Lupon chairman or pangkat, and that no conciliation or settlement has been reached as certified by the Lupon secretary or pangkat secretary, as attested to by the Lupon or pangkat chairman, or unless the settlement has been repudiated by the parties thereto. So basically, this provision requires the parties to a dispute when their case should be subjected to barangay conciliation first to submit their case first to barangay or to the Lupon chairman or to the pangkat prior to filing of a complaint in court, because filing it directly in court would be filing it prematurely, and it could be a ground for the dismissal of the case because of non-compliance to a condition precedent, which is the compliance with the barangay Katarungang Pambarangay law. On the later part of our report, the step-by-step procedure on the conduct of barangay conciliation would be further explained. Now, let us know which cases should undergo barangay conciliation first. So, the general the Lupon of each barangay shall have the authority to bring together the parties actually residing in the same municipality or city for amicable settlement of all disputes. So, as a general rule, any kind of dispute, so long as the parties actually reside in the same municipality or the same city, it should be subjected to barangay conciliation. So that is the general rule. However, for this rule, there would be exceptions. So for these exceptions or for these instances, even if the parties reside in the same municipality or in the same city, there is no need for barangay conciliation. First, where one of the parties is the government or any subdivision or instrumentality thereof. So if the government is involved, there's no need for barangay conciliation. Next, where one party is a public officer or employee and the disputes relates to the performance of his official functions. So for this exception, there are two qualifications. First, the party should be public officer or employee. And second, the dispute should be related to the performance of the said public officer or public employee's official functions. The third exception, for offenses punishable by imprisonment exceeding 1 year or a fine exceeding 5,000 pesos. Next, offenses where there is no private offended party. So there is no private offended party, no need for barangay conciliation. Next, where the dispute involves real properties located in different cities or municipalities, unless the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. So for this, the real property involved is located in different cities or municipalities, which will also be exempted. Next, for disputes involving parties who actually reside in different cities or municipalities, except where the parties are resident of adjoining barangays of different cities or municipalities, and the parties thereto agree to submit their differences to amicable settlement by an appropriate lupon. So for this, even if the parties are resident of different cities or municipalities, if their barangays adjoins each other or they are resident of adjoining barangays, they may still be subject to barangay conciliation if they agree to submit to amicable settlement by an appropriate lupon. So next, such other classes of disputes which the President may determine in the interest of justice or upon recommendation of the Secretary of Justice. So for Section 412, Paragraph B of the Local Government Code, these are still exceptions to the general rule. So for these instances, the parties may go directly to the court. First, where the accused is under detention. Second, where a person has otherwise been deprived of personal liberty, calling for habeas corpus proceedings. Third, where actions are coupled with provisional remedies such as preliminary injunction, attachment, delivery of personal property, and support pendente lite. And fourth, where the action may otherwise be barred by the statute of limitation. Then another set of exceptions to general rule. Labor cases as provided in the Labor Code. All disputes arising from employee-employer relationship shall be under the exclusive jurisdiction of the labor arbiter. Second, dispute arising from CARP or Comprehensive Agrarian Reform Program. Third, actions to annul judgment upon a compromise, which may be filed directly in court.
Good day everyone, I'm Randall Chan from Group 9. I'll be reporting about Katarungang Pambarangay, specifically about its nature of proceedings, quantum of evidence, and due process requirements. An important provision to remember is Section 418 and 415. All proceedings for settlement shall be public and informal. Public may be excluded from the proceedings in the interest of privacy, decency, and public morals. Section 415 states that appearance of parties in person, no counsel allowed. So next is nature of proceedings. Before filing or instituting directly in court, parties must go through the lupon, chairman, or the pangkat. No complaint, petition, action, or proceeding involving any matter within the authority of the lupon shall be filed or instituted directly in court or any other government office for adjudication unless there has been a confrontation between the parties before the lupon, chairman, or the pangkat and that no conciliation or settlement has been reached as certified by the lupon secretary or pangkat secretary as attested to by the lupon or pangkat chairman, or unless the settlement has been repudiated by the parties thereto. So next, it is a precondition for dismissal of formal adjudication, and the requirement is merely a procedural technicality. So a case filed in court without compliance with prior barangay conciliation procedure, which is a precondition for formal adjudication, may be dismissed upon motion of defendants, not for lack of jurisdiction of the court, but for failure to state a cause of action or prematurity, or the court may suspend proceedings upon petition of any party and refer the case motu proprio to the appropriate barangay authority. So next, affects the sufficiency of the plaintiff's cause of action and makes complaint vulnerable to dismissal on the grounds of lack of cause of action or prematurity. So the requirement for barangay conciliation is merely a procedural technicality. Non-compliance thereto only affects the sufficiency of the cause of action and renders the complaint dismissible on the ground of failure to comply with the condition precedent pursuant to Section 1, Rule 16 of the Rules of Court. The institution of the action, whether civil or criminal, without complying with the requirement merely renders the action premature for file to exhaust all administrative remedies. The action could be challenged not on lack of jurisdiction over the subject matter of the claim over the offense charge, but that the filing of the complaint or information is premature, since a condition resident for filing of the claim has not been complied with. So next is the process of Katarungan Pambarangay. So first, complaint is filed with the barangay captain orally or in writing. Next, Lupon Secretary records the complaint and assigns a docket number. Barangay captain issues summons for parties to appear before him. Then barangay captain conciliates the party or arbitrates the case. If settlement is reached, case is considered closed. If conciliation or arbitration fails, then the barangay creates a pangkat. As a pangkat conciliates the parties or arbitrates the case. Then if agreement is reached, arbitration award is made. Case is closed. But if arbitration fails or pangkat's decision is validly repudiated, the case may be taken to court. So this is important to remember for the due process requirement for barangay conciliation proceedings. So I'll be providing you with common rules of procedure for barangay conciliation. Okay, first is proceedings shall be informal but orderly, but without regard to technical rules of evidence. Next, proceedings shall be open to the general public, except the punong barangay or pangkat chairman may, at the request of a party or upon the punong barangay's or pangkat chairman's own initiative, exclude the public from the interest of privacy, decency, and or more public morals. So the party should appear in person without the assistance of counsel or a lawyer. So next is the proceedings shall be recorded by the Lupon, Barangay Secretary, or the Pangkat Secretary as the case may be. The Secretary shall note the date and time of hearing, appearance of hearing, parties, name of witnesses, and substance of their testimonies, objections, and resolution, and such other matter as will be helpful to a full understanding of the case. Next, punong barangay or pangkat chairman issues summons, notice of hearings, and subpoena for the personal appearance of the parties and their witnesses at the barangay proceedings. Last is the punong barangay or the pangkat chairman administers oath in connection with any matter relating to all Katarungan Pambarangay proceedings. So next is the quantum of evidence required for Katarungan Pambarangay proceedings. So here, in mediation or conciliation, the Lupon chairperson or pangkat simply assists the parties in defining issues and exploring solution to develop a mutually accepted settlement. In arbitration, the Lupon chairperson or pangkat is given the power to render decisions on the dispute with a prior agreement of the parties to be bound by it. The parties shall present evidence as to the facts and merit of the case to the arbitrator. So, the quantum of evidence required for Katarungan Pambarangay is substantial evidence with probable cause. So, substantial evidence is required, which is such amount of relevant evidence that a reasonable mind might accept as adequate to justify a conclusion. So, that's it. Thank you, everyone.
We will now tackle the rules of procedure. Section 409 of the revised Katarungan Pambarangay Law provides where to file the complaint. It gives different instances to identify the venue for the settlement of the dispute. So first, if both parties are actually residing in the same barangay, the amicable settlement shall be brought before the Lupon of said barangay. Second, if the parties involved had their actual residences of different barangay within the same city or municipality, it shall be brought in the barangay where the respondent or any of the respondents actually resides at the election of the complainant. Third, all disputes involving real property or any interest therein shall be brought in the barangay where the real property or larger portion thereof is located. Fourth, for those arising at the workplace where the contending parties are employed or at the institution where such parties are enrolled for study, it shall be brought in the barangay where such workplace or institution is located. For individuals living or actually residing in different barangays and different cities or municipality, no need to undergo barangay conciliation or barangay proceedings, but parties may still agree to undergo the barangay conciliation if adjoining cities or municipalities. In the event that both parties do not agree, they may go to court directly. So, can you object to the venue of the proceedings? The law provides that yes, provided that said objection is raised in the mediation proceedings before the punong barangay. Otherwise, the same shall be deemed waived. Moreover, any legal questions which may confront the punong barangay in resolving objections to venue therein may be submitted to the Secretary of Justice or his duly designated representative, whose ruling thereon shall be binding. So we have heard the procedure. So first, the complaint is filed with the barangay captain orally or in writing. Next, the Lupon Secretary records the complaint and assign a docket number. After which, the barangay captain issues summons for parties to appear before him. Subsequently thereto, the barangay captain conciliates the parties or arbitrates the case. The mediation lasts for 15 days. If settlement is reached, the case is considered closed. If conciliation or arbitration fails, the barangay captain creates a pangkat tagapamayapa. Now, the pangkat tagapamayapa conciliates the party or arbitrates the case wherein the conciliation proper lasts for 15 days and can be extendable for 15 more days. If any party fails to appear, the pangkat chairman shall set a date for the absent party to appear before him to explain the reason for the individual's absence. Now, if the agreement is reached or arbitration award is made, the case is closed. However, if the arbitration fails or pangkat's decision is validly repudiated, the case may be taken to the court and the certificate to file action can be issued. So what are the consequences of failure or refusal to appear? For the complainant, it is a dismissal of complaint. Second, is barred from seeking judicial recourse for the same cause of action, and he may be punished by the city or municipal court for indirect contempt. For the respondent, it is the dismissal of counterclaim, and the individual is barred also from seeking judicial recourse for the same cause of action, and he may also be punished for indirect contempt by the municipal or city court. So is the amicable settlement and arbitration award set to take effect immediately? Section 416 of the revised Katarungang Pambarangay law provides that no, the amicable settlement and arbitration award shall have the force and effect of a final judgment of a court upon the expiration of 10 days from the date thereof, unless repudiation of the settlement has been made or a petition to nullify the award has been filed before the proper city or municipal court. So for the execution of settlement, agreement, or arbitration award, for within 6 months from the date of the settlement, it may be enforced by the Lupon chairman. If the disputant has not complied with the settlement, a motion for execution with the punong barangay may be filed, and the punong barangay shall set a hearing not later than 5 days from the date of the filing of the motion. So, if after 6 months from the date of the settlement, it may be enforced by the municipal trial court having jurisdiction over the settlement. So, how to repudiate the settlement? By filing with the Lupon chairman within 10 days from the date of the settlement, and the failure of which to repudiate within the set time limit shall be deemed a waiver of the right to challenge on said grounds. So for our related forms, we have 25 different forms. So we have the notice to constitute lupon, the appointment, the notice of appointment, the list of appointed lupon members, the oath of office. We also have the withdrawal of appointment, agreement for arbitration, subpoena, arbitration award, the complaint, the notice of hearings, officer's return, summons, notice for constitution of pangkat, notice to choose and pangkat members. For the next is the notice of hearing for conciliation proceeding, the amicable settlement, the notice of hearing if failure to appear. Next is the certification to bar counterclaim. Next is the notice of hearing for the execution. Moreover, we also have the repudiation, certificate to file action, motion for execution, and notice of execution. So we have here the forms. The notice to constitute the lupon and the appointment, the notice of appointment of the appointed lupon members. We also have the oath of office of the punong barangay, or the in the office of the punong barangay, the withdrawal of appointment. We also have here the complaint to be filed in the office of the lupong tagapamayapa, the notice of hearing for the mediation proceedings, the summons, the officer's return, the notice to chosen pangkat member, the notice for constitution of pangkat, the notice of hearing for the conciliation proceeding. We also have here the subpoena, the agreement for arbitration, the arbitration award, the repudiation, the amicable settlement, the notice of hearing in case the complainant or any of the parties involved failed to appear or refused to appear. Second is the notice of hearing. Next is the certification to file action. And we have the certification to bar counterclaim, certification to bar action, the notice of hearing, the motion for execution, and the notice of execution. That is all for Group 9.